Welcome to Let's Talk U.S. Immigration. Right now, all across America, people who are here completely legally, visa holders and even green card holders, are lying awake with the same frightening question. Is it safe for me to leave the country and come back?
Yeah, it's a question we hear literally every day.
Right. A parent is ill abroad, a wedding is waiting, a long-delayed trip home beckons. And yet the fear is real, that if they leave the life they have built here, they might not be allowed back in.
It's paralyzing for so many people.
Today, we answer that question honestly because you deserve the truth. Not vague comfort and not needless panic. We will walk through who can travel with confidence, who needs to be careful, who should not board a plane until they have spoken to a lawyer, and exactly how to protect yourself if you do travel. Before we begin, everything you are about to hear is designed to inform and educate. Immigration law is complex, it is changing quickly in 2026, and every case is different. What you learn here should always be discussed with a qualified immigration attorney before you take any steps, and that is especially true for this topic. We are the AI hosts for this series, walking through research carried out on behalf of the team at the law offices of Chris M. Ingram.
It's a critical mission today. We're taking all this legal research compiled by our attorneys and, trying to translate it into actionable protection for you. Because that fear you just described, it isn't just some abstract policy debate.
No, not at all.
It is a daily living reality for thousands of people.
To put a face on this, our legal team actually put together a composite profile based on real cases they see, every single week. Let's call her Ananya. Picture this setup. Ananya is sitting alone in an airport departure lounge. It's late. The fluorescent lights are buzzing overhead. She's staring at her phone, looking at a text from her mother half a world away that simply says, "Come home, we need you." Her father is very ill.
Oh man, that's heavy.
Right. Now, Ananya has lived and worked legally in the United States for years. She has an apartment lease in her name, a career she loves, a whole community. Her entire life is anchored here.
Yeah.
But in that departure lounge, she is suddenly she's paralyzed by a fear she never anticipated.
And it isn't the fear of, the grueling 15-hour flight or even the immediate dread of her father's health, as crushing as that is.
No, it's the sudden icy realization that if she gets on that plane, if she leaves the country she has built her life in, she might not be allowed back in, like the door could just lock behind her. So, sitting there in the dark, she does what thousands of legal immigrants are doing right this second. She types into her phone, "Is it safe for me to travel?"
It's the midnight question.
Yeah, the midnight question. Today's mission is to answer Ananya's question, your question, if you are listening and navigating a similar situation with absolute unvarnished honesty. We are talking about the difference between a safe, routine trip and, losing your entire life in America. And it all comes down to what you know before you book that ticket.
Knowledge here isn't just power, it is an absolute shield.
Totally. And I'll tease this right now. Stick around until the end of this deep dive because we are going to break down a surprising, incredibly calming fact about cell phones and digital privacy at the border that honestly shocks almost everyone who hears it.
Oh, yeah. It's a massive detail that completely changes how people should, pack their digital lives.
Right. But before we get to the phones, before we even start sorting out who is safe to travel and who is sitting on a powder keg, we have to establish the foundational reality of the U.S. border right now. We have to absorb one very hard foundational truth.
And this is tough for a lot of people to swallow.
I know this might be tough to hear, especially if you hold a permanent document and feel like you've crossed the finish line. What is this foundational truth?
The truth is that your visa and even your green card is not an absolute guarantee that you will be readmitted to the United States.
Wait, hold on. Let me push back on that for a second.
Sure.
If I hold a green card, it literally says permanent resident right on it. The government gave it to me. Why on earth wouldn't that guarantee my entry? Explain the actual mechanics of what happens when you step up to that booth.
Right. So it comes down to the legal definition of what is happening at the border. Every single time you return from abroad and present yourself at a port of entry, whether that is JFK Airport, a land crossing down in Texas, a seaport, whatever, a Customs and Border Protection officer, a CBP officer, is performing a legal reassessment of whether you may come in.
So it's not just a hello.
No, not at all. Now, For most travelers, most of the time, that reassessment feels invisible. It feels like a total formality. You slide your passport across the counter, the machine beeps, you get a nod, and you walk to baggage claim.
Right. It feels like they're just checking that the card actually belongs to you, like a rubber stamp.
Exactly. But legally, it is not a rubber stamp. It is a strict authoritative checkpoint. And the scrutiny at that checkpoint in this current landscape is, well, it's more intense and unforgiving than it has been in decades.
But why, though? Did Congress pass some dramatic new border legislation overnight that made it a fortress for legal residents?
No, and that is exactly what catches people off guard. It isn't about some dramatic new law on the books. It is entirely about scale, technology, and posture.
What do you mean by posture?
Well, over the last few years, the agencies involved in immigration, law enforcement, border security, they have achieved unprecedented levels of data integration. The systems talk to each other now. Federal databases pull from local county court records, state police systems, and international watch lists, like simultaneously.
So an issue from a local jurisdiction that used to just, I don't know, gather dust in a county filing cabinet is now instantly pinging on a federal CBP officer's screen in Miami.
Precisely. They conduct deep, continuous vetting.
Yeah.
Vetting no longer stops just because you passed an interview and were granted a visa 3 years ago.
Yeah.
The algorithms are constantly running in the background. Yeah. Combine that massive data infrastructure with a highly aggressive enforcement posture at the border, and you have a totally transformed environment. Issues that once stayed quietly in the background, an old minor arrest where charges were dropped, a paperwork lapse from a decade ago, a long absence from the country, these things surface instantly on a screen at the exact moment you are handing over your passport.
The exact moment you are exhausted, jet-lagged, standing under those bright lights, and just trying to get back to your own bed.
Exactly. Now, I want to be super clear here. None of this means you cannot travel. What it means is that you must travel informed. The single most dangerous thing you can do right now is leave the country assuming your physical document alone, the plastic card or the foil sticker in your passport, will magically carry you back in without a human being making a discretionary judgment about your life.
I want to try an analogy here to see if I am grasping the reality of this.
Let's hear it.
So having a visa or a green card is basically like having a ticket to an incredibly exclusive VIP concert. You bought the ticket, it's totally valid, it has your name printed on it, you followed all the rules to get it.
Right.
That ticket gets you past the line in the parking lot and gets you to the front door of the venue. But the bouncer standing at the door still has the absolute legal authority to check your ID, to search your pockets, to look at your past behavior at other clubs, and to decide in that split second if you're actually getting inside the concert tonight. The ticket is just permission to arrive at the door. It is not a bypass of the bouncer.
That is an excellent way to visualize it. I really like that. The document gets you the privilege of standing in front of the CBP booth. The officer sitting in that booth makes the final determination of whether you are entering the country.
Okay, if we accept that no document is a 100% bypass of the bouncer, let's explore the strongest ticket a person can hold, the green card. Lawful permanent resident status.
Yes, let's talk about that.
If someone listening have a green card, they are probably feeling a spike of anxiety right now. Let's dispel some of that, because our legal team is clear that green card holders have tremendous power if they understand how to use it.
They really do, and it is vital to ground ourselves in that reassuring foundation. If you are a lawful permanent resident, you have a massive legal shield that a temporary visa holder just does not possess. The core distinction is this: by law, a returning permanent resident is generally not treated as someone who is seeking admission.
That sounds like a legal technicality.
Yeah.
What is the practical difference between returning and seeking admission?
Oh, the difference is night and day. When a tourist, a student, or a temporary worker arrives at the airport, they are legally seeking admission. That means the burden is entirely on them to prove all over again from scratch that they don't violate a massive checklist of admissibility laws. They have to prove they aren't a security risk, a health risk, an economic risk, and so on. But a green card holder, generally speaking, bypasses that entire baseline test. The law recognizes you as someone who already lives here. You are simply coming back from a temporary trip outside your home.
And Attorney Chris Ingram's team highlights a rule here that feels like, honestly, the holy grail for permanent residents. Tell me if I have this right. A border officer literally cannot take your green card away.
Yes. I want every permanent resident listening to write this down or just drill it into your memory. A CBP officer simply does not have the unilateral legal power to strip you of your permanent residence status.
That is huge.
It is. Only an immigration judge sitting in a formal federal court proceeding can decide that you have lost your green card. No matter how angry the officer gets, no matter what they say to you at the airport booth, they cannot cancel your permanent residence with the stroke of a pen.
That is incredible. But knowing the bureaucracy, I know there has to be a catch. There is always a catch. Our research points to a ticking clock. The strength of that green card shield degrades the longer you stay out of the country, right?
You hit the nail on the head. The law draws a very sharp critical line at 180 days. That is roughly 6 months. If your trip outside the United States is shorter than 180 days, your reentry is usually smooth. You retain that massive legal shield of not being treated as someone seeking admission.
Wait, let me break this down. Are you saying that the second my flight takes off from JFK, a silent stopwatch starts ticking, and the longer I stay away, the more I am essentially inviting the U.S. government to start wondering if I've abandoned my life in America?
That is exactly the mechanic. Once your continuous trip crosses that 180-day threshold, the legal presumption flips. You lose the shield. You can now be treated as someone seeking admission all over again.
Oh, wow.
Yeah. The officer now has the full authority to start asking those invasive questions. What is your criminal history? Are you working abroad? Did you buy a house over there? Where are your U.S. tax returns?
And what if that stopwatch keeps running? Like, what if someone goes back to care for a sick parent and they're gone for 13 months?
If you are outside the U.S. for a continuous year or more, the situation escalates from a tough interview into a full-blown legal crisis. At the 1-year mark, your physical green card is generally considered legally invalid on its own for reentry. It ceases to function as a valid entry ticket.
You just can't use it.
Right. You would likely need to apply for special, complex documentation like a returning resident visa at a consulate abroad just to try and get back to the border. So the baseline advice from our legal team is brutally simple. For green card holders, the length of your trip dictates your risk. Keep your trips comfortably under 6 months whenever you possibly can.
Because the longer you are away, the more ammunition you give CBP to claim you don't really live here anymore.
Exactly.
Which brings us to something genuinely terrifying that our team has identified. We just established the golden rule. Only an immigration judge can take your green card, not a border officer. But there's a massive trap where travelers are actually tricked into stripping themselves of their own rights.
Yeah.
It's called the I-407 trap.
Ugh. Yes. This might be the single most critical warning in this entire discussion for permanent residents. It is happening constantly in airports all across the United States, and it can literally vaporize someone's American life in a moment of panic. The I-407 is a government form. Its official intimidating title is the Record of Abandonment of Lawful Permanent Resident Status.
So in plain English, it's the I voluntarily give up my green card and agree to leave form.
Yes, and the danger is how this form is deployed. Imagine a green card holder returning from a long trip, maybe 7 or 8 months away. They get flagged at the primary booth. The officer takes their passport and escorts them to secondary inspection.
Oh, that's the dreaded back room. The one with the metal tables, no cell phone use allowed, and you just sit there for hours wondering what is happening.
Exactly. It's incredibly intimidating. The traveler is exhausted, terrified, maybe their English isn't perfect, and they just want to see their family waiting in the arrivals hall. An officer comes in, aggressively questions them about their long trip, and then slides this I-407 form across the metal table.
Let me guess. They play a psychological game. They say something like, look, you clearly don't live here anymore. Just sign this form and we'll let you catch a connecting flight home. Or, if you don't sign this, I'm going to put you in detention.
That is precisely the tactic our attorneys see. It is an intense, high-stakes psychological pressure cooker. The officer wants to resolve the case quickly. They want a signature. But we have to drill this into the listener's head. Do not do the officer's job for them.
I want to make sure I am fully grasping this. You are telling me an officer can legally print a piece of paper, put it in front of me, pressure me to sign it, and if my hand shakes enough and I sign it just to get out of that horrible room, I have essentially deported myself.
Yes. And I want to deliver a very calm, very firm directive here, drawn straight from attorney Chris Ingram's playbook. You are never, under any circumstances, required to sign the I-407. No officer can physically or legally force you to sign it. Go back to our golden rule. Only a judge can take your green card. But if you sign that form, you are personally, voluntarily surrendering the exact status the officer legally cannot take from you. You are handing them the victory.
I worked directly with Judith, Studi, Gladys, Amy, and Amit on my EB1 case. The process was smooth. My case was patiently created and submitted to USCIS. I did receive an RFE, which is not uncommon, but Studi was able to address USCIS's concerns, and I eventually received my I-140 approval. I spent lots of time on the phone with Studi and Judith. They are both very knowledgeable, and if there is anything that they aren't sure about, they quickly research it for you. I highly recommend this firm for EB1 cases.
So let's role-play this for a second. A listener is in that freezing secondary room. The officer is yelling, telling them they're going to lose their green card anyway, sliding the pen across the table. What is the exact actionable response the traveler needs to give?
The correct response is to remain incredibly calm, be perfectly polite, but be an absolute brick wall. You decline to sign. You state clearly, "Officer, I respect your position, but I wish to keep my permanent resident status, and I am requesting a hearing before an immigration judge."
To say, I want to see a judge.
Yes. Now, let's be realistic about what happens next.
Yeah, they're not going to be happy.
Not at all. The officer will be frustrated. They might confiscate your physical plastic card temporarily. They might issue you a notice to appear, which is the document that starts removal proceedings in immigration court. That sounds terrifying to a traveler. But a judge's hearing is where your rights exist. It is a legal forum where you can breathe, hire an attorney, gather your evidence, and actually fight for your life in America.
Which is 1,000 times better than signing away your life at an airport counter at 2 in the morning.
Infinitely better. Because if you sign that I-407, undoing it is a legal nightmare. Even if you argue later that you were exhausted, confused, or under extreme duress, the legal hurdle to convince the government to reverse a voluntarily signed abandonment form is monumental.
Okay, the ultimate proactive defense is knowing your rights and knowing you can say no. But let's pivot to how you avoid ever getting dragged into that secondary inspection room in the first place. For the listener who wants to bulletproof their permanent residence, how do they travel wisely?
The overarching strategy, according to our attorneys, is to prove, quietly and in advance, that your true permanent home is the United States of America. Think about the psychology of the border officer. The officer looking at a returning resident who has been gone for 4 months is really just trying to answer one core question. Did this person subtly move their life abroad?
Right. They're hunting for abandonment. They want to know if you're just using the green card as a glorified tourist visa.
Exactly. So your job is to answer that question before they even open their mouth to ask it. You do this by traveling with what our legal team calls the quiet folder.
I love the sound of this, the quiet folder.
Yeah.
I'm imagining a physical file. What goes into it? I assume it's more than just a passport.
It is a physical, organized holder that you carry with you in your personal carry-on bag. Never, ever put it in checked luggage. It is packed with concrete, undeniable evidence of your ongoing life in America. First and foremost, your most recent U.S. tax returns filed as a resident.
Let me stop you there. Won't I look like a crazy person pulling out my tax returns at an airport booth? Won't that make me look incredibly defensive?
Well, you don't hand them the folder the second you walk up. You hand them your passport and your green card. But if the officer raises an eyebrow, scans your record, and says, "You were in London for 5 months, where do you actually live?" You don't get into a verbal argument. You don't start pleading. You quietly open the folder and pull out the tax return, your current apartment lease, your mortgage statement, recent pay stubs from your American employer, or, your business and corporation documents if you own a company.
Oh, I see. You pull out your state driver's license, your utility bills, bank statements showing you've been paying for electricity and Netflix in America the whole time you were gone.
Exactly. It shifts the entire dynamic of the interaction. You replace a subjective argument with undeniable, boring paper evidence. It signals to the officer instantly that they are dealing with someone who is deeply rooted in the U.S. and who knows exactly what they are doing.
That makes perfect sense. Now, what if a listener knows in advance that they're going to break the 6-month rule? Say, Ananya's father's illness requires her to be out of the country for 9 months to manage his estate. She knows she's crossing into the danger zone.
Our research points to a very specific, powerful tool for this scenario. It is called a reentry permit. If you anticipate an absence longer than 6 months, or certainly one approaching a year, you must apply for a reentry permit before you leave the United States.
What does that actually do mechanically? Like, how does it protect you?
It is a document, officially the I-131, that acts as a pre-approval of your extended absence. It allows a permanent resident to stay outside the U.S. for up to 2 years without the government automatically assuming they have abandoned their residence.
So it's basically telling the government, hey, I'm leaving for a long time, but I am absolutely coming back. Here's my formal notice.
That is exactly what it is. It visibly signals to CBP that before you even packed your bags, you legally declared your intention to return. Now, there is a catch. You must be physically present in the United States when you file the application, and you generally have to complete your biometric fingerprinting appointments here before you leave. You cannot fly to Paris and then realize you need a reentry permit.
It's not a retroactive magic wand.
It is not. And even with a permit, your ties to the U.S., that quiet folder, still matter immensely. But having the reentry permit dramatically de-escalates the risk of a long-planned absence. A traveler who keeps routine trips short, carries a quiet folder, and proactively secures a reentry permit for long absences is someone who has built an absolute fortress around their permanent residence.
Okay, we've talked extensively about green card holders. They have the 180-day rule, they have the I-407 right of refusal, they have reentry permits, they have deep, defensible roots. But I want to transition to a massive group of listeners whose position is inherently temporary and, frankly, completely exposed. Visa holders.
This is a vital pivot in our deep dive. The honesty of our legal team's research requires us to state clearly that the landscape for visa holders is profoundly more vulnerable than for green card holders.
We're talking about H-1B tech workers, international students on F-1 visas, people visiting on B-1, B-2 tourist visas, and even folks traveling from Europe or Japan under the Visa Waiver Program, the electronic system for travel authorization, which we'll pronounce as Esther for our discussion here, just to keep things clear.
Yes. For all of these categories, you have to remember what a visa actually is. It is not permanent residence. A visa is, at its heart, just a fragile, temporary permission to travel to a U.S. border and ask the bouncer for permission to come in.
And the defining risk of this current moment in 2026 is that these fragile permissions are being revoked with startling frequency, often while the person is sitting in their home country thinking everything is fine.
That is the nightmare scenario. And a revoked visa generally cannot be used to return. We go back to that massive data sharing and ongoing vetting ecosystem we talked about earlier.
Right, the algorithm's running in the background.
Exactly. The government is continuing to vet people long after they are initially let in. If derogatory information surfaces in any local or federal database, it can trigger an immediate automated refusal or revocation of the visa.
Here's where it gets really interesting and honestly terrifying for anyone who has ever had a misunderstanding with the law. Our legal research points out a staggering reality. This derogatory information includes old overstays, minor compliance slips, and crucially, arrests that never led to a conviction.
Yes, that's a huge point.
Hold on, let me stop you because this feels incredibly unfair to the average person. We are raised on the concept of innocent until proven guilty. Are you telling me that a student could have had a misunderstanding at a protest years ago or a messy traffic stop where they were arrested, but the prosecutor looked at it, realized they did nothing wrong, dropped all the charges, and they were found completely innocent? Wait, can that arrest record still lock them out of the country when they try to come back from a vacation?
Yes. That is exactly what our attorneys are warning about, and it is vital that listeners understand the mechanical reason why this happens. It happens because immigration admissibility operates on a completely different, inverted, and much stricter standard than the criminal justice system.
Break that down for me. How can the standard be different?
Think about criminal law. In a criminal courtroom, you have the presumption of innocence. A prosecutor must prove you are guilty beyond a reasonable doubt to convict you. It is a very high bar. If they can't meet it, the charges are dismissed, the record might even be expunged, and you walk free.
Right.
But immigration law flips the burden of proof entirely. When you are a visa holder standing at the border seeking admission, the burden is 100% on you to prove that you are admissible.
So you are guilty until proven innocent at the border.
Practically speaking, yes. If a CBP officer looks at their screen and sees a record of an arrest, say for a controlled substance or a crime involving moral turpitude, they do not need a criminal conviction to deny you entry. The legal standard for them is merely reason to believe. If they have a reason to believe you engaged in the conduct that led to the arrest, that is often enough to revoke a visa or deny admission. The standard of proof is dramatically lower.
So because of the data sharing, the border officer sees the expunged arrest record instantly. And because they don't need a judge's conviction, they just cancel the visa right there at the booth and send you on the next plane out.
That is the reality. And for people traveling under the visa waiver program, the ESTER system, it is even more precarious. ESTER is not a visa, it is a waiver of a visa. And one of the conditions of using it is that you waive your right to challenge a denial of entry.
You waive your right to fight back.
Yes. If you show up with an approved ESTER and the officer sees an old arrest or suspects you are coming to work illegally, they can deny you entry. And you generally have no right to see a judge, no right to appeal. You are just sent back. This is why every single international trip for a visa holder or an ESTER traveler carries immense weight right now. The question isn't just, is my document unexpired? The real question is, will something in the deep background of my life be reassessed and used against me while I am completely exposed outside the country?
Man, that's heavy. Which brings us to a perfect, agonizing example of visa vulnerability. Sometimes a traveler doesn't even have a dark secret in their past. They have no arrests, no overstays. They simply try to follow the rules and renew their paperwork, and they get caught in what our legal team calls the stamping trap.
This is a scenario that is currently turning routine administrative errands into months-long nightmares, physically separating people from their jobs, their homes, their pets, and their families.
Set the stage for us. Walk me through the mechanics of the stamping trap.
Let's use the example of an H-1B tech worker. They have a great job in Silicon Valley. Their underlying legal status inside the U.S. The approval notice from immigration is perfectly valid for another 2 years. But the physical visa stamp, the colorful foil sticker inside their passport, has expired.
Right. And while you can sit in your living room in California with an expired stamp, as long as your underlying status is valid, the second you leave the country, you need a valid stamp to re-enter.
Correct. You cannot board a flight back to the U.S. without a valid, unexpired stamp. So this worker plans a quick 2-week trip home to India or the U.K. to go to a U.S. consulate, do a quick interview, get a new stamp in their passport, and fly back to their job. Historically, this was a smooth, predictable process.
But 2026 is a different world. What is the trap?
The trap is that U.S. consulates globally are dealing with unprecedented backlogs. They're overwhelmed, and they have implemented incredibly rigorous security protocols. The worker goes for their interview, expecting to be approved on the spot. Instead, the consular officer hands them a piece of paper under Section 2221 and says, "Your application requires administrative processing."
Administrative processing. I've heard horror stories about this. What actually is it?
It is essentially a bureaucratic black hole of security and background checks. It happens when the consular officer cannot approve the visa immediately because a system flagged something that requires review by agencies back in Washington. It could be that the applicant's name matches someone on a watch list. It could be that their degree is in a sensitive field that triggered a hit on the technology alert list, the TL, meaning the government wants to make sure they aren't transferring sensitive technology.
How long does this black hole last?
That is the terrifying part. There is no statutory timeline. There is no firm end date. It could take 2 weeks. It frequently takes 3 to 6 months. And during this entire agonizing period, the applicant is completely locked out of the United States.
Because their old stamp is expired, and the new one is sitting in a pile on a desk in Washington waiting for a security clearance.
Exactly. They are stranded abroad. We see cases where people lose their jobs because their employer cannot hold the position open for 4 months. They miss mortgage payments. They are separated from spouses who remained in the U.S.
Now, I know the old trick for this. Historically, if you were from, say, France, but you didn't want to fly all the way back to Paris and risk getting stuck, you would do something called third country national processing. You would just pop over the border to Canada or Mexico, go to the U.S. consulate there, get the stamp, and walk right back across the border. Is that still a thing?
Our attorneys strongly warn against assuming that is a safe loophole today. It has become highly risky. Consulates in third countries like Canada or Mexico are increasingly hesitant to process complex visa renewals for people who do not actually reside in those countries. And here's the true nightmare. If you go to a consulate in Canada, apply for a stamp, and they put you in administrative processing.
You're stuck in Canada.
Exactly. You are stuck in a hotel in Toronto, far from your home country, far from your life in the U.S., racking up expenses with no end in sight.
That is brutal. Is there any exception at all? Any way to travel with an expired stamp and not get trapped?
We worked with Miguel Gonzalez on our EB-1A petition, and it was an excellent experience from start to finish. His deep expertise and meticulous guidance were instrumental in our case being approved without any RFE. A testament to the high quality and thoroughness of his preparation, Miguel stands out for his timely communication and prompt responses, ensuring we never felt left in the dark during such a critical process. His professional behavior and strategic advice provided us with the clarity and confidence we needed to navigate the complexities of the process. We are incredibly grateful for his support and highly recommend Miguel Gonzalez.
Our legal team outlines one narrow, highly specific exception called automatic revalidation. Under very specific conditions, certain visa holders whose physical stamp has expired can travel solely to Canada or Mexico for a trip of less than 30 days and re-enter the U.S. using their valid underlying status documents, like their I-797 approval notice, without ever needing to visit a consulate for a new stamp.
Okay, let me try an analogy here. Automatic revalidation sounds like a legal rubber band. You are anchored in the U.S., and you can stretch that rubber band across the border into Canada or Mexico for a short vacation of less than 30 days. And because you never let go of the rubber band, it snaps you right back into the U.S. safely without a new stamp.
That is a brilliant way to conceptualize it, but you have to understand exactly what causes that rubber band to snap and break, leaving you stranded.
What breaks the rubber band?
First, time and geography. If you stay 31 days, the band breaks. If you travel from Canada to Europe, the band breaks. But the biggest trap is this automatic revalidation is completely voided if you actually apply for a new visa while you were on that trip.
Wait, so if I stretch my rubber band into Toronto for a 2-week vacation and figure, hey, while I'm here, I might as well walk into the U.S. consulate and try to get a new stamp just to be safe, I destroy my own safety net.
Yes. The moment you apply for that new visa stamp, you cannot use automatic revalidation to come back. If the consulate puts you in administrative processing, you are stuck in Canada. The rubber band is severed. Furthermore, automatic revalidation doesn't apply to citizens of certain restricted countries at all.
So the overarching lesson here for visa holders is that renewing a stamp is no longer a quick, casual errand you fit in between sightseeing. It is a massive risk assessment that requires planning for the absolute worst-case scenario.
You must plan for the possibility of getting stuck.
Because these traps are so severe, whether it's the I-407 trap destroying green cards or the stamping trap bankrupting visa holders, we need to draw a very hard line for the listener. Our team's legal research specifically outlines exactly who needs to stop, pause, and seek legal counsel before they even look at flight prices. Let's walk through the absolute do not board list.
This is critical triage. If you fall into any of these 5 categories, the advice from attorney Chris Ingram's team is unequivocal. Do not get on that plane until you have sat down with an immigration attorney.
Let's hit the red flags. Number 1, any criminal history.
Yes, and as we exhaustively discussed, this includes any arrest, even if there was no conviction, even had a judge told you the record was expunged or sealed. State-level expungements often do not erase the record from federal immigration databases. CBP will see it, and it can trigger a denial.
Red flag number 2, previous overstays, gaps, or immigration irregularities.
If you ever stayed past the allowed time on your I-94 arrival record on a previous visit, even by a few days, or if you worked without authorization 5 years ago, leaving the country is the moment all of that history gets scrutinized. Unlawful presence can trigger automatic 3-year or 10-year bars from re-entering the country the moment you depart.
So you could be living here fine, but the physical act of leaving triggers a 10-year ban.
Exactly. The departure executes the penalty.
Red flag number 3, green card holders with long absences. We covered this deeply. If your absence is nearing that 180-day mark, or certainly if it is approaching a year, do not just fly back blindly and hope for a friendly officer.
You need a legal strategy and a robust quiet folder before you face that booth.
Red flag number 4, anyone in the middle of a pending immigration process.
This is a trap that breaks hearts every day. If you have an application pending with USCIS, for example, an adjustment of status to get a green card, or a change of status from a student to a worker leaving the country without specific permission, like advance parole, can legally abandon that application entirely. You could ruin years of expensive legal paperwork just by scanning your boarding pass.
Wow. And finally, red flag number 5, citizens of countries facing travel restrictions or processing freezes.
The geopolitical landscape is volatile. If your home country is on a restricted list, or if diplomatic relations are strained resulting in consulate closures, routine travel is never routine. You could be locked out simply because of the passport you hold.
If we connect all of this to the bigger picture, the logic of early intervention is undeniable. Spending an hour with an attorney before you leave is infinitely more valuable than desperately trying to call an attorney while you are sitting in a detention room at a foreign airport. Once the border officer denies you entry and puts you on a flight back, You cannot reverse time. You cannot unring that bell. The time to fix a problem is from the comfort of your living room in America, not from a holding cell at JFK.
An ounce of prevention is worth a pound of cure, especially in immigration law.
Okay, we have thoroughly covered the traps, the red flags, and the worst-case scenarios. But let's take a breath. For the vast majority of listeners who can travel, who don't have arrests or overstays, how do they ensure they breeze through CBP without an anxiety attack? Let's give them the practical protection guide.
Our legal team provides a very clear, proactive checklist. It's about being a disciplined, well-prepared traveler. Item 1, always carry original documents, your physical green card, your valid passport, your visa stamp. If you are a worker, carry your original I-727 approval notice. If you are a student, carry your original I-20 certificate of eligibility with a fresh travel signature from your school.
And crucially, never put these in a check bag. If the airline loses your luggage in Frankfurt, you lose your ability to enter the United States. Keep them on your person.
Always in your carry-on. Item 2, carry the quiet proof of U.S. ties. We detailed this with the quiet folder, tax returns, lease agreements, job letters. Item 3, keep your trip short. For green card holders, aggressively respect that 180-day line.
Item 4, check your compliance before you leave. Fix problems from the inside, not the outside.
Exactly. If you are an H-1B worker, ensure your recent pay stubs exactly match your required prevailing wage. If you are a student, ensure you are maintaining a full course load. Do not leave the country if your internal paperwork is messy.
And item 5, maintain absolute consistency and honesty at the booth. Don't over-explain. Don't try to be overly charming. Don't guess at answers. Just answer the specific questions truthfully, consistently, and concisely.
Less is more at the primary booth.
Now, earlier in the show, I promised we would reveal a surprising fact about cell phones at the border, and we are finally here. The issue of digital privacy. This is an area of massive pulsing anxiety for modern travelers.
And rightly so, because our entire lives, our banking, our private conversations, our photos, our legal documents are in our pockets. The foundational rule you must understand is that the U.S. border is a constitutionally unique zone. Under the border search exception of the Fourth Amendment, CBP has incredibly broad authority to inspect electronic devices.
Yeah.
They do not need a traditional probable cause warrant from a judge to look through your phone or your laptop.
So practically speaking, you need to treat your phone exactly like a piece of physical luggage. Don't carry digital files across the border that you wouldn't want physically unpacked and laid out on a metal table for a federal officer to examine. But our research points out a massive, catastrophic mistake people make when they try to hide things.
Yes. Never, ever wipe a device before crossing the border. Do not delete your WhatsApp. Do not scrub your text messages. And absolutely do not factory reset your phone before you land.
Why? I mean, if I don't want them to see my private texts with my spouse, why shouldn't I just delete the app?
Because to a CBP officer trained in behavioral analysis, a wiped phone looks aggressively suspicious. If they look at your phone and see no messages, no photos, or a fresh install, it practically screams that you are hiding something illegal. It almost guarantees that you will be pulled into secondary inspection, your device will be seized for a deeper forensic data recovery investigation, and your entry will be delayed.
Okay, so wiping it is a terrible idea. Here is the big surprise we promised, straight from the legal team's analysis. Let's say you are at the booth. An officer asks for your phone, and they tell you to unlock it. What are your actual constitutional rights in that specific moment?
This is a fascinating and critical legal nuance. Generally speaking, under current interpretations of the Fifth Amendment, which is the amendment that protects you against forced self-incrimination, you cannot be forced by an officer to hand over your memorized alphanumeric passcode or password. The knowledge held securely inside your mind is considered protected testimony.
Wow. Okay, so they cannot legally force me to speak the numbers to my passcode. That feels like a huge protection. But what about modern phones? What about Face ID or a thumbprint scanner?
That is exactly where the law splits, and this is the detail that shocks people. While your memorized passcode is considered protected mental testimony, your physical bodily characteristics, your face, your thumbprint, are not. They are physical evidence. Therefore, officers can legally ask you, and in many jurisdictions physically compel you, to unlock a device using biometrics.
Wait, let me get it straight. If my phone unlocks with Face ID, a border officer can literally hold my own phone up to my face, let it scan my eyes, and open it.
In many circumstances, under current operating procedures, yes, they have the authority to do exactly that to facilitate a border search.
That is a staggering legal distinction. So what is the takeaway for the listener? Should they be going into their settings and disabling Face ID or Touch ID before their plane lands?
Our attorneys advise that this comes down to a personal risk assessment. If you are traveling with highly sensitive corporate data, privileged attorney-client legal communications, or deeply personal information you wish to fiercely protect, disabling biometric unlock and relying solely on a complex alphanumeric passcode provides a much higher level of legal friction against a search.
Because they can't force you to give the passcode.
Correct. However, you must weigh that protection against the reality of the border. If you refuse to provide a passcode when asked, CBP has the authority to seize the physical device.
They can just take my iPhone and say goodbye.
Yes. If they cannot access it, they can seize it and send it to a forensic lab for cracking. But here is the calming, rational fact that our research emphasizes, which most people don't know. If a device is seized because you wouldn't unlock it, it doesn't disappear forever. It is typically returned to you within a few days or a few weeks, assuming no criminal material is found. They give you a formal receipt, you go home, and eventually the device is mailed back to you.
So it is incredibly inconvenient to lose your phone for a week, but it is not the end of the world, and it doesn't necessarily mean you are being deported.
Exactly. It is a procedural hurdle, not a catastrophe. So what does this all mean? It means travel clean. Don't bring unnecessary sensitive data across the border on a primary device. Understand the massive legal difference between your passcode and your face, and know that even if the absolute worst happens and your device is temporarily seized, you have rights and you will survive the process.
It comes back to the core theme of this entire discussion. Uncertainty is not helplessness. The prepared traveler is the protected traveler.
Absolutely.
Let's bring this narrative full circle. Let's go back to Ananya, sitting in that departure lounge at the beginning of our deep dive. She's staring at her phone, the fluorescent lights humming above her, weighing the beautiful life she built in America against the father who desperately needs her halfway across the world. She shouldn't have to make this monumental decision alone in the dark.
No, she shouldn't. Because guessing in the dark, relying on internet rumors, is exactly how catastrophic mistakes happen at the border. Deep knowledge of her specific situation, her exact visa type, her complete background history, the specific planned length of her trip, that knowledge is her only true protection.
I want to leave you, the listener, with a final thought to mull over, something that builds on everything we've unpacked today. Think about the invisible, heavy psychological toll this system takes on the American workforce in our communities. We have hundreds of thousands of brilliant doctors, software engineers, teachers, and neighbors. They're here legally, they pay taxes, they buy homes, they contribute massively to the fabric of this country. And yet, they are terrified to visit their dying parents abroad or to attend their own sister's wedding because of these invisible bureaucratic tripwires.
It creates a profound, quiet chill on their lives. They live with a constant low-level anxiety.
Exactly. What does that do to the soul of a country? We spend so much time in the news talking about physical borders, about walls and checkpoints and x-ray machines. But what we are really building, what the bureaucracy has built, is a psychological border. It is a heavy border that legal immigrants carry with them in their minds every single day, internalizing that fear, even when they are safely sitting on their couch inside their American living rooms. They're living with a permanent asterisk next to their feeling of belonging.
It is a remarkably heavy burden, and it underscores exactly why understanding the mechanics of the law, stripping away the mystery, the jargon, and the panic is so deeply essential.
So let us leave you with the heart of it. In 2026, your visa, and even your green card, is not an absolute guarantee of getting back in because an officer reassesses you every time you return, and the scrutiny right now is real. But uncertainty is not helplessness. If you're a green card holder, keep your trips under 6 months when you can, keep strong proof that your life is rooted in America, and never, ever sign a form giving up your status under pressure, because only a judge can take your green card, not an officer at a booth. If you are a visa holder, understand that visas are being revoked more readily now, even over old or minor issues. So think carefully before you leave, and never treat renewing an expired stamp abroad as a quick errand. And if you have anything at all in your history, a record, an overstay, a pending case, or you come from a country facing restrictions, do not board that plane until you have spoken with an attorney. The strategies in this discussion are for educational purposes only, and this area is changing fast. Your situation is unique, and the law and offices of Chris M. Ingram are here to help you understand your specific options. If you are weighing a trip and feel any uncertainty at all, Please reach out before you travel, not after. Visit breakthroughhanase.com for a free consultation. Thank you for listening, and we will see you next time.